Good day. I am Loveview Zain, student code 0341651, semester 3, batch August 2021 of Taylor's Law degree, and I am presenting an assignment under the Land Law module, code LAW 61504. I will critically evaluate whether the requirement for formality detracts the autonomy of the landowner in dealing with his or her own property, following Patricia Critchley's article provided by Ms. Putri. I'll start by providing the definition of formality. According to Critchley's article itself, in law, formality is a requirement that matters of substance must be put into a particular form to obtain a specified legal effect. A similar opinion extracted from another journal article I found by Professor Marius Zalocki. He defined formality as requirements to comply with a specific form for a legal act to occur. Now, I will talk about the current position of formality in relation to land law. So according to Halsbury's law, a landlord must satisfy two sets of legal requirements if he or she wishes to grant a legal lease of land for a fixed term. Firstly, the landlord must be granted a right of exclusive possession for a certain term. This requirement has been applied and followed in these following cases. 1 is Street and Mountford, 1985, and the case of Prudential Assurance and London Residuary Body in 1992. Now, these are the substantive requirements. The formality needs fall under Section 52 of the Law Property Act 1925, where it states that all conveyances of land or any interest therein are void for the purpose of conveying or creating a legal estate, which includes a lease, unless it is made by deed. Besides Section 52 of the Act, land law also contains other rules under the form of formality, such as Section 19 of the Land Registration Act 1925, where registered land most of the time must be registered in order to achieve full legal acceptance. Moreover, formalities can regulate the exercise of a power. For example, this party A has a power to make a gratuitous binding promise if A party with a legal freehold, has a power to grant B a legal lease of 21 years. There are three functions which must be present, known as 1, evidentiary, which falls under the Statute of Frauds 1677, and 2, cautionary, and 3, channeling. Now, I will evaluate the formality requirement in land law. With the existence of the formality rule under the Law of Property Act 1925, the substantive requirement has become insufficient as they are still required to cast into a specific form, that is known as a deed, in order to achieve legal effect or to obtain the creation of a legal lease. Besides that, according to Jeremy Bentham, the 3 points in relation to the Statute of Frauds are beyond dispute due to the mischievousness of it, the uselessness of it, and the corruption in which it was begotten and has been preserved. Furthermore, there are problems with the formality rules itself. A contract of guarantee is only enforceable if it is in writing and is signed. The possible problems with formality rules is 1, the cost and delay, 2, frustration of reasonable expectations, 3, undue complexity and technicality. And lastly, lack of transparency in the law itself. Formalities are sometimes important in equity as well. In the case of Crabb and Arun DC, 1976, and Walsh and Lonsdale, 1882, a general rule was formed, making formality an important aspect where A is under a contractual duty to transfer a legal estate to B, or to grant B a legal estate or interest. Then B acquires an immediate equitable interest, and B agrees to terms so B moves in. B pays rent, but they never executed the deed that was required for B to get a legal lease. Thus, B does not have a legal lease, but a periodic tenancy based on the facts that B was in possession and B was paying rent. So B has a lease, but not on terms agreed. The court held that B did not have a legal lease, but A and B have an agreement in a contract. So in equity, B is regarded as having a lease where the equitable lease is on the same terms as the agreement. This includes A's power to ask for a year's rent in advance, because there is a contract to grant a lease that gives B an equitable lease. Thus, formality does not apply all the time. There must be a disposition. It does not apply to a compromise agreement in a boundary dispute, as seen in the case of Yeats and Line in 2013, and also does not apply to a unilateral act, such as the exercise of an option to purchase, as seen in the case of Spiro and Glencrown Properties Limited in 1991. A contract for the sale or other disposition of an interest in land can only be made in writing and only by incorporating all the terms which the parties have expressly agreed in one document, or where the contracts are exchanged in each. The terms may be incorporated in a document either by being set out in it or by reference to some other document. The document incorporating the terms, or where contracts are exchanged, one of the documents incorporating them, but not necessarily the same one, must be signed by or on behalf of each party to the contract. Thus, we can conclude that the requirement for formality thus detracts the autonomy of the landowner in dealing with his or her property in certain situations. That is all from me, Ms. Putri. Thank you. Have a nice day.